So welcome back, everyone. Our topic for this video is the responsibilities of auctioneers and gallerists that we alluded to in the last session in relation to authentication, to provenance. Kyle, just briefly, to whom and for what are auctioneers and gallerists responsible?
Well, here in the UK, this is actually one of those areas where the popular perception can lead many people to an erroneous conclusion because it can't be stressed enough that the auctioneer is solely the servant and agent of the seller alone. He is not in any form of a contractual relationship with the buyer. Even the contract of sale generally is concluded between seller and buyer. The auction house will always place themselves as an agent of the seller. They don't want to receive any responsibilities to the buyer whatsoever. And that, in many ways, makes a lot of sense. If the auctioneer owes moral, contractual, and most importantly, fiduciary duties to the seller, complying with any similar duties to a buyer would leave them in an insoluble conflict of interest. So as a general rule, auctioneers do not owe any duties to the buyer, which is why, up until relatively recently, the only premium payable on an auction sale was the seller's premium, as it was to them and them alone that the auctioneer was providing a service. However, as we've seen in all of these videos, auction houses take the inch that you've given them and take another 7 miles. So it's become increasingly clear that auction houses and gallerists have been misusing that freedom. In 1975, of course, Christie's and Sotheby's famously began to charge buyers premiums for the first time, and within months, the entire art market followed suit. Furthermore, in the contemporary art market, it's now become very common for auction houses to seek out and actively pursue specialist collectors and investors as potential purchasers for particular high value artworks. So even in terms of lower value items, the argument that the only people who are actually interacting with the art market are professionals with knowledge of the market is increasingly difficult to justify in a world of online bidding and much wider interest really in acquiring art generally. So these days, of course, wild claims are made in catalogues to entice buyers, and often potential high value buyers will be flown into a city and entertained at the expense of the auction house as part of a package, allowing them to view a particular object that the auction house really wants them to buy. There have thus been moves in the courts, and there's no doubt about this. This is another area where the courts are trying to tighten up on this. So there's been this move in the UK courts towards beginning to think about imposing duties on the auction house to the buyer as well as the seller. So we first of all saw that in a case called De Balcony against Christie's. Now, in that particular case, Christie's sold a painting claiming in the catalogue it was by Egon Schiele. It turned out that actually 94% of the painting was overpaint, and Schiele's signature on the canvas had been forged. Now, in those circumstances, the court held that there was a duty upon Christie's to ensure that the catalogue entry was correct, and this they had not done. So in theory, Christie's could have been held liable for that mistake in the auction catalogue. Basically, the court held that it was so obvious that the painting was not by Schiele that it was not reasonable for Christie's to conclude that it was. However, because Christie's terms and conditions explicitly waived liability for statements as to authorship in the catalogue, they were let off. The court basically stressed very highly in that particular case that they weren't particularly happy with that as a rule. However, it is the current UK law. I can see a lot of pressure being put to change that particular rule. More recently, in Thompson, again against Christie's, the auction house actively pursued a very wealthy Canadian heiress as a potential purchaser of a pair of purportedly ancient porphyry vases set in what they said were Louis XV bronze mounts. They turned out to be 19th century fakes. The court held that the way that that buyer had been pursued, the way that they had actually gone after this particular person, flown them to London, entertained them, gave them a tour of the auction house with the directors of Christie's, showing them the item, that had actually given rise to a new special duty of care to that specific buyer, which was much more extensive than the general duty of care an auction house would owe to bidders to take reasonable care with cataloguing. So yet again, the courts are hinting at the fact that they really want to put this duty onto auction houses who are misusing this power of bringing buyers in. However, yet again, Christie's escaped the duty in this particular case because they were able to show that a reasonable auctioneer of their stature would probably have held those particular vases to be Louis XV. So they still managed to escape liability here. So whilst the buyer was not successful in achieving damages in either of those cases, I think it seems very clear that the stage is now set in the UK for a further expansion of the duties owed by the auction house to the buyer. And in a world where buyers' premiums can themselves be in the tens of millions of pounds, and where specific buyers are very actively being courted by auction houses, it really does seem increasingly unjustifiable that auctioneers can still argue that they shouldn't owe any duties whatsoever to the buyer. So I really do think this is an area we're going to see a lot of legal development.
I wanted to talk a little bit about the actual breakdown, a little bit about the what duties are owed, because I think that we say duties of care, but I want to kind of break that down a little bit. So part of that is the duty to investigate, right? So that the auctioneer needs to make sure that that about title and provenance and you can't just take the seller's word, and that's important. That you have to look at does the seller actually own it? Can the seller actually pass title? It's the duty to disclose known or suspected title problems. Is there a gap in provenance? Is there, are there foreign claims? Are there suspicious exports? And you need to disclose that to potential buyers. There's also a duty to refrain from selling works that may be stolen. And selling stolen property could also trigger criminal exposure. For example, in California, we have a California Penal Code sections that deal with sort of dealing in stolen goods in general. So that could expose that person to criminal. And we'll get into that more in the criminal and anti-money laundering issues. In California, there are also very specific fine arts consignment statutes that adds fiduciary obligations when a consigner is an artist, something called the Fine Prints Act. And then there's also something called UCC Article 2. So the Uniform Commercial Code is statutorily enacted in I think all states. And there are implied warranties of title that an auctioneer has, unless, and this is important, they disclaim them in their, and they disclaim them appropriately in their terms and conditions in their contracts. And that's why they need very fine art lawyers to make sure that they have those disclaimers in place.
This is fascinating. And I have a question where we as art historians come into this story, because many auctioneers, many gallerists are, of course, art historians, but they also rely on very specialist expertise, by a handful of selected kind of experts in museums or in universities. Now, what is the duty of these art historians vis-a-vis the kind of due diligence question towards the buyer? And we know that art institutions have become increasingly reluctant to engage with these kinds of publications. Catalogue raisonné is the kind of standard, gold standard of what's by whom and in what relationship. Is it workshop? Is it copy? Is it, attributed to, and so on. So the UK Art Law Guide says this is due to well-publicized disputes and legal challenges. So this is really kind of complex. And I wonder if we can use the example of the case of Thome versus the Alexander and Louisa Calder Foundation, Steve, as an example.
Sure, and I'll first say, like, just about the catalogue raisonné, that theoretically that is so crucial to not just art historians, which is certainly important as well, but also very important to the art market. It's important to it can the value of a piece of art can rise or fall dramatically based on whether it is authenticated, whether it is an authenticated piece of work in a catalog raisonné. And so
Just to say in
collectors,
that respect, just to get in there, when I was talking about that previous case of Thompson against Christie's, the fact that something appears in a catalogue raisonné and the auction house can point to that, that means that they are reasonable in coming to the conclusion that that piece of work is by the person it's said to be. And that can be a total defense to the auction house if something appears in a catalogue raisonné.
that's right, exactly. And so the practical problem there is that institutions, as you noted, and institutions are increasingly reluctant to issue catalog raisonnés and to really authenticate from an institutional standpoint, artworks, and there's a reason for it. And first of all, there's significant legal risk, okay, and I'll just note that my understanding is the Warhol, the Basquiat, the Paula Krasner, and the Liechtenstein boards have all shut down their authentication services. So the case that you referenced, Thorne versus the Alexander and Louisa Calder Foundation, a 2009 New York Appellate Division case, and it's widely seen as sort of this hallmark of that led to a really dramatic change in authentication practices, particularly for institutions. So Thorne plaintiff sought to sell 3 works that were associated with Alexander Calder. The potential buyers basically said, look, we need to have these on the catalog raisonné, or else they're unsellable. And so Thorne asked the Calder Foundation, and the Calder, after much to do, the Calder Foundation refused to authenticate or include them in the catalog raisonné. And Thorne sued the Calder Foundation. He alleged a wrongful refusal to authenticate. He alleged a market manipulation, and he sought a court order that would require inclusion, essentially the injunction, mandatory injunction requiring inclusion. And the court concluded that those with authority to authenticate have no legal obligation to authenticate art or include a specific artwork in the catalog, and because it's inherently subjective, and so it's their judgment, and they don't have that obligation to say yes or no. And that has dramatically changed, really, that as I mentioned, that institutions are increasingly reluctant to authenticate because it could lead to liability for them, and they don't have a requirement, and so it affirmed right to decline that authentication, and it contributed to that sort of vast change in that market.
Yeah, and it's exactly the same situation in the UK. Catalogue raisonné, as I say, are of absolutely critical importance, and they're used constantly by auction houses and gallerists in actually authenticating works. Yet, whilst the UK courts haven't dealt with this point directly, they have dealt with it several times indirectly, and they've consistently said that they will never make a rule that a catalogue raisonné can be forced to include or exclude a particular work, because that is a question of fact requiring someone to have artistic expertise. It is not a fact which can be decided by a judge in front of a court. It's something that must be decided by the experts. It is a matter of opinion, and for that reason, they will not enter into forcing catalogue raisonné to either include or exclude works. But exactly as Steve said, the catalogue raisonné as a kind of concept is something which is very quickly going out of fashion, because there's such a worry that there could end up being potentially a liability, because it does have a huge value, a huge impact on the value of the work. Without inclusion in a catalogue raisonné, it will be virtually impossible to sell a work as being by that artist. I mean, we've seen recently, obviously, in the UK market and the global market with the Salvator Mundi, the power that an expert saying that a particular work is by an artist has in making that work the most valuable painting in existence. So this is really something which is of huge importance. And again, going forward, is something I think art lawyers will be getting more involved in.
I just want to end with an example, a hypothetical example, let's just say. So a collector buys a piece of art for, let's say, 6 figures, whether it's authenticated or not, whether an auction house it represents that it's of this particular artist, when he or she goes to get insurance and get an authentication certificate for it, the authentication process comes back and says, I don't think that it is. The value, and it's not in the catalog raisonné. There's no other the institution of that artist, if there is one, won't authenticate it. And what that dealer, what that expert says in some way, essentially means that the artwork could go from a six-figure artwork to what is exactly the value. And so you could, like, what is the insurance value of that? Is it $400,000, or is it $1 or $5 of something that you could get at some thrift sale? And literally this is what this turns on, or can turn on.
And that process, just to sort of add in at the very end of this section, that process of authentication is absolutely fraught with risk. And I think we are seeing allegations of this being leveled against, for instance, the people who authenticated the Salvator Mundi, that if you get a group of experts together, all of whom have a financial interest in proving that a work is by a particular artist, the temptation is certainly there to overcome, shall we say, any doubts in your head in order that you can get that ultimate profit. And I think there is a huge potential within that idea of authentication for criminal activity.
That goes to that issue of collusion, and that goes to the issue of, and it's a perfect segue to perhaps the next.
Perfect. From the morally dubious to the downright criminal. That's what we're dealing with in the last section, when we'll talk about art in relation to criminal law, forgeries and fakes, money laundering, and tax evasion. So thank you, and see you in a moment.